Everyone, we've got people rapidly joining. Welcome to the Indo-Dutch Cybersecurity School for 2025. It's great to see everyone. The numbers are jumping up. So yeah, so I'll just do a quick introduction. My name is Alexander Krevendam. I've been working kind of behind the scenes to, organize the school, and so it's great to see that we've finally begun. Leonard is here as well. He's also been helping. And yeah, there is his face. I don't know if you can see him or not, but yeah, he is here as well. You see, everyone, this is lecture one of 20. So we've got lots of exciting lectures for you coming up. Today's lecture is called Data Privacy in Focus, an overview of GDPR and DPDPA. Quite a mouthful, but that's always a good thing. It means you're going to get a really good lecture, I find. So without further ado, I want to introduce Mahi Gupta. And Mahi Gupta is an accomplished data privacy expert with extensive experience in privacy strategy, consulting, and risk assessment. She holds a master's degree in law and is a certified CIPP/E and CDPO. Yeah, she's an expert. Currently, she's working with an AI-based product startup, ensuring regulatory compliance and privacy by design adherence. She's an active speaker. She does amazing things and is an advocate for privacy in international forums, like IAPP. So with that, a great CV, I think I will hand over to Mahi. The floor is yours, and we're all really excited to listen to your amazing lecture.
Thank you. Thank you very much, Alexander, for giving me this opportunity and for all the amazing people in the audience for, being patient enough to listen to me for this next 1 hour that we have. So like Alexander mentioned, today we are going to talk about, privacy and specifically two major regulations, which are, European regulation, which is governed by GDPR, and India, which is DPDP Act, right? And we are going to talk about what are the different kinds of, obligations of controllers, processors, how did the landscape of privacy even get evolved, and what are the other, nuances within the act, what are the key terminologies that you need to keep in mind while going, into these kinds of, privacy risk assessments, and what are the key takeaways that you would have from this. So let me just, share my screen, and please let me know if you can, see it.
Looking good from my end. Yeah.
Beautiful. All right. So the first thing that we are going to talk about is So I think the first thing, first things first, why is privacy important in an enterprise? Why is privacy even relevant for an organization? And what is it that you're going to accomplish, or you're going to, be getting from privacy within the enterprise landscape, right? So the first thing that you need to keep in mind is the fact that privacy is all about protecting the personal information. It is a step deeper in the cybersecurity realm of things, where personal information is given the maximum priority, and any unauthorized access or use of this personal information is considered as a breach, and there are significant fines which are levied if these kinds of activities are happening within the enterprise. The other thing that, yes, Sadvik. I think somebody has a question.
What we will probably do, but it's just easy, I think, for the flow, is let's keep maybe the Q&A to the very end. So keep your question in mind. I think it is probably easier. And then we have 10 minutes at the end dedicated for the Q&A. Sorry, I should have mentioned that in the very beginning. My apologies. So keep your questions in mind. And at the end, we have a Q&A.
Yes. All right, so we'll park all the questions for the last 10 minutes. We'll reserve the Q&A. You can, keep writing your questions, and I'm happy to answer as many questions as possible. right? So now talking about, I'm going to touch at a very high level. What is it that, one means by privacy in an enterprise? So it means, largely safeguarding the personally identifiable information. It also means that people have restricted access to confidential data. So when I say confidential data in the privacy realm of things, it means PII and SPI, that is personally identifiable information and sensitive personal information, right? And the idea is to reduce the risks that are there via various organizations collecting huge amount of data sets that are there, right? And it is also about introducing the principle of transparency and accountability so that organizations do not, have this idea that they own the data. It is the user's data ultimately, right? And they have a fair amount of responsibility to be able to answer to those users what are the things that they're collecting, how they're collecting, what is it that they're doing with the data, and how are they consuming the data within their data ecosystem, right? And it's also about not only responding to user requests but also sensitizing people who are touching your data, via various services that are being offered to you as a consumer. What is it that they're doing with the data? That fair amount of, sensitization should also be there. And this is why trainings are also something which are very relevant in for privacy in organizations, right? Now, let's talk about why organizations need privacy. The basic and the most fundamental organizations need is to ensure that they're building, trust with their, consumers. At the end of the day, they are providing, for the fact that controller the data principals or the data, subjects have control over their personal data. They're ensuring that there is empowerment and transparency within all their processing activities. They're also ensuring that confidential data, when it is being consumed within their environment, is being used in the most restricted and the most sustainable manner, right? And what it helps the organization do is achieve compliance. It also ensures that there is better consumer trust, there is an enhanced organizational reputation, and there is also a room for flexibility and innovation at the same time, right? And privacy has been a fundamental right in all landscapes that have come up with privacy regulations, right? So right to privacy is considered as the most fundamental right for any individual. Now, talking about what are the, impacts that could happen if there are weak privacy practices that exist, within an enterprise. Let's talk about what are the impact of, weak privacy practices on an organization. So one is regulatory penalties, right? We have regulators coming up every now and then in each geography which are tightly regulating how organization is consuming personal data of the people they're providing services to. Now, there is also a reputational damage. Now, just imagine if there is an organization which is, constantly in the face of, data breaches that are happening, your personal data is getting lost, they are not telling you exactly how they're using or they're consuming your data, there is a good chance that you will not want to continue the relationship forward with those organizations, right? There is also an operational disruption angle to it, right? Why? Because a breach or a regulatory penalty does not only mean that you're losing face in the market. It also means that your own business operations, business as usual, what we call it, is also getting disrupted because there are impacts. There are certain things that you need to do as an ongoing basis which will get impacted. Why? Because you are having ongoing compliance issues, you're having less customer base. There is also this business advantage that you might be at a loss of because customers are not choosing you, right? Now let's talk about how does these weak privacy practice affect the individual. What is the impact on the individual? There is a loss of trust that is there. There is identity theft. There could be frauds that could be done out of these identities that have been lost. There could be a loss of autonomy. So when I say loss of autonomy simply means that as much amount of data has been lost by the organization, it means that you have no control over how the data is being consumed, what the data is being used for. There is a entire spiral of how the data is moving from one business function to the other business function, and you're having no control over what is it that I give the data for, let's say X purpose, and my data is now being used for ABC or A through Z purposes, right? So that means there is a loss of autonomy in that. And it also can lead to psychological harm. So psychological harm in the sense that when you do not have control over what kind of data is being used about you, there could be different kinds of let's say spam calls that might be coming to you. You might be receiving calls from different kind of people, different kind of enterprises that have no business with you in general, and it might also have some impact on you, right? Now, so this is at large what I mean when I say that why is privacy important within an enterprise and what is the need for privacy, right? So we'll go and we'll talk about first GDPR. So let's talk about how did GDPR even evolve, right? Uh, privacy is something which is very, very close to, I think, European, Union's heart, right? And in 2012, privacy was governed through e-privacy directives, right? And in the year of 2016, that's when GDPR was adopted on the 27th of April, and in 24th on the 24th of May 2016 is when GDPR came into force. There was a 2-year grace period that was given to organizations to adopt this regulation, to become in compliance with this regulation. So officially in the May of 2018 is when GDPR became fully enforceable, right? Now, the way GDPR generally functions is there are a lot of litigations that have happened. There are a lot of case laws that have evolved the understanding of how we perceive GDPR as a legislation. And one of the most popular one of the most popular, I would say, cases that came out of all the judgments that have been there is the Schrems 2 case. Now this came in the year of July 2020. What it did was, the US and EU privacy shield, which allowed for organizations to, transfer data amongst EU and US entities, they were made invalid, and there were, additional measures that were, adopted for the purposes of ensuring that there is a smooth cross-border transfer that happens, right? And there is also a EU-US data privacy adequacy decision that has come up, right, which has happened in the year of 2024. It is very fresh. So this is what is, in short, the evolution of GDPR, so to say, right? Now, let's talk about what are the core provisions of GDPR. I'm not going to touch all of these. I'm just going to give you a high level understanding. GDPR comprises of 99 articles in total, right? All of these articles are spread across, the definition part of things. What are the rights of the data subjects? Who are controllers? Who are processors? And I'm going to talk about all of these concepts, in the further coming slides. So, um, just to give you a nutshell idea, 99 articles are what comprise in the GDPR legislation, right? Apart from that, it talks about what are the things that are covered under GDPR. How do you, make transfers? What are the supplementing acts? What are the penalties that are going to be levied? How do supervisory authorities function? And so on and so forth, right? So let's talk about what are the key terminologies, or what are the key, points that you need to remember from a GDPR perspective. So personal data, all of these have been defined under Article 4 of GDPR. The first thing that we're going to talk about is personal data. So personal data under GDPR means any information, any piece of information that can identify an individual, right? Such as the person's name, their ID number, their location data, so on and so forth. Any piece of information that can reveal the identity of a person will be categorized as personal data. Now, there is another category of data, right, under GDPR, which is called special category data. Now, special category data is basically the kind of data that requires even further protection. Now, what comprises of special category of data? So, data that relates to a person's health, their biometrics, their religious belief, or it could be their political affiliations, their sexual orientation, so on and so forth, right? So all of these categories of data are considered as special categories of data under GDPR, and any entity which deals with these kinds of data, they need to have stronger protections, because it is presumed that these kinds of data sets have they pose higher risk to individuals, right? Now let's talk about the second two concepts. So who's a data subject? So any persons whose data is being collected, that person is going to be the data subject, right? So let's take for a let's take an example, right? And I'm going to explain all of these by example so that you understand better. Any person whose data is being collected is the data subject in the sense of GDPR, right? And the controller is going to be the entity who collects that data for the purposes of doing certain activities on that data. And a processor is any individual or any entity who processes the data further on behalf of a data controller, right? And a third party is any person, okay, other than the controller to process the personal data under the controller or the processor's direct authority. Now let me put all of this in example so that you understand better. So let's assume Mahi Gupta. Mahi Gupta in this case is going to be the data subject. She gave the data to DSCI for the purposes of doing this master class, right? So DSCI will become the data controller in this regard, right? Now let's say DCI uses some other entity for the purposes of contacting each and every individual to let them know of where can you attend the class, where can you get the recording of this, where can you get the PPT of this, and so on and so forth, right? So they are going to become the processors of DSCI, right? And third party is going to be, let's say, any other party apart from DSCI and this X party that I was talking about, who's going to be involved in processing of data. Now, personal data, my name, my phone number, my Aadhaar number, where do I reside, all of this is the personal data. But anything which has to do with, let's say, my retina scan, or, which, religious affiliation am I associated with, or, what is it that I politically am aligned to, all of these are special categories of data when it comes to Mahi Gupta, right? Now, processing, think of it like all operations that you can think of that are going to be performed on the data, such as collecting of data or recording of certain things, structuring of data for it to make more sense, or let's say doing some analytics over the data, or using the data, disclosing the data to a processor. All of these are called processing of data as activities, right? Now, all right. Now, GDPR talks about, 7 principles of data processing that each and every organization needs to follow. So the first principle that we have is lawfulness, fairness, and transparency. What it means is that each organization needs to ensure that whatever data they are processing, it is in the most lawful, fair, and transparent manner, with a fair amount of respect towards the data subject rights, right? So this is where you have all of your, privacy notices coming in, consents being taken. So this is where an organization ensures that they are doing all the operations on the data in the most lawful, fair, and transparent manner, right? The next that we have is purpose limitation. Now, purpose limitation is very simple. What it actually means is that if you require the data for a certain kind of purpose, you should limit the use of that data for that particular purpose itself, and you should not start repurposing the data for all XYZ activities within the enterprise. Let's say that I gave my consent for the purpose of, DSCI sending me promotional emails, right? But they are sending me all other kinds of emails other than the promotional emails. Now they are repurposing the data, right? What it means is uh, GDPR says that organization must follow purpose limitation at the utmost level. They should ensure that whatever data is being collected for a specific purpose, it should be used for that purpose and that purpose alone, right? The next we have is data minimization. What it means is, it means that organizations should collect and process the bare minimum amount of data that is required for their business operations. See, we as data controllers have the tendency of being data hoarders. So when I say data hoarders, it simply means that we collect unfiltered amount of data just because we might need it in the future. So this is where, GDPR talks about data minimization as one of the core principles of data processing. Organizations need to be mindful of collecting and processing only the minimum amount of data which is necessary for their purpose, right? Now, talking about accuracy. Now, accuracy is one of the principles out of which one of the rights of the data subject also springs out. What accuracy as a principle means is that an organization needs to ensure that they are taking all the efforts to ensure that the personal data of the data subjects is kept accurate at all point in time. So to give you an example, one of the rights that springs out of this principle is the right to update, right? Now what it means is, let's say that my title was initially, before I started a relationship with any XYZ organization, my title was Miss Mahi Gupta, and eventually within that time period, while that relationship was existing with that enterprise or organization, my title changed to Mrs. Now when my title changed to Mrs., there are a lot of other corrections that would be required. Let's say in specific, in terms of, if I talk about India, right, instead of father's name, now I'm going to have my spouse's name, right? So all of these are something that I can ask as a right from the entity for them to update the data, and they have to ensure that they are taking all possible measures to update the data at all points in time, right? Now let's talk about storage limitation as one of the principles. Now storage limitation, what it ideally means is that if you have identified X purpose for collecting a data, you should only keep that data for as long as you're serving that purpose. Once that purpose is over, you should not keep holding on to the data. You should delete that data, right? And you should only keep that bare amount of data with you, which you might require for, let's say, some reporting or regulatory purposes. Now, talking about integrity and confidentiality. Now, integrity and confidentiality, what it means is that it is an organization's duty and responsibility to ensure that data is not misused, it has not been unauthorizedly accessed, it has not been lost through any measure within the enterprise. So they need to ensure that the integrity of the data is kept at the strictest level within the enterprise ecosystem, right? Now accountability, what it simply means is for every processing activity that the organization is doing, they have to have an accountability towards the data subjects, and they also need to have an accountability towards the data rules that have been published, and they need to ensure that they are doing everything within their power to keep the data, to process the data in the most lawful manner, to ensure that the integrity and the confidentiality of the data is maintained at all points in time, right? So these are what are the principles of data processing within an enterprise. Now we've spoken a lot about what are the rights that have been given. So under GDPR, individuals have been given with 7 rights, right? So let's talk about these rights. Now these rights are basically enshrined in the articles from article 12 to article 22 within the GDPR legislation. Let's talk about the first right. Now the right to be informed. What it means is that individuals have the right to know how their personal data is being processed. So you as an individual can ask the entity how they're using your data, what they're using your data for, and who are they going to share that data with, right? So everything related to how your personal data is being processed is a right that you can ask about from the entity or the organization, right? Now, right to access. Now, right to access means that individuals can request access to their personal data that is being held by the organization. So I can tomorrow go and ask DSCI, what data are you holding about me? And they will have to oblige by that request, right? The next that we have is right to data portability. Now, sometimes what happens, now this is very common in, the telecom industry, and this is very common in the banking sector, and something which is very, very relevant in, let's say, the internet thing, in the internet space, right? So we would want to shift our services from one provider to the other because we feel dissatisfied with that, in with that service provider, and so on and so forth, right? So this is where the right to data portability comes. Now, individuals have the right to request personal data to be transferred from one organization to the other organization, and this right has to be met in a machine readable format which is easily accessible and can be consumed by the other organization to whom the data is being transferred, right? Now let's talk about right to erasure and rectification. Now this is where I was talking about accuracy, as one of the principle. The right to erasure and rectification is what springs out of accuracy as a principle. Now individuals have the right to request for the correction or deletion of any inaccurate or outdated personal data about themselves, right? So that they can ensure that all the data that is being kept about them by an organization is up to date, and it is also accurate in the most in the best sense, right? Now, right to restrict processing. So this is one of the most beautiful rights, I think, that have been given to individuals, which is around, if and as an individual or as a data subject, I feel that the organization is not respecting certain rights, they are not processing in the most fair manner, I have the right to request the organization to temporarily stop processing my personal data, right? Now there are certain conditions that have to be met under this, but if I am able to prove that the organization is not taking into consideration the best privacy practices, I can ask them to temporarily stop processing my personal data. Now, right to object is another right which empowers individual where they can object to the processing of their personal data, especially if it is for direct marketing or when legitimate interest is taken as a basis for doing any processing activity within the enterprise. Now, there are a lot of organizations, especially in the banking and the insurance sector, which are now using AI to, be able to calculate your, CIBIL scores, and to be able to give you, what kind of loan percentage, or let's say what kind of interest rate could be charged to you, right? So if you are an individual residing under GDPR, you have the right to not be subject to automated decision making. So individuals where, decisions are being made solely on the basis of an automated processing, where, it could be profiling, or there could be, some, let's say, some services being offered to them, with certain interest rates, or so on and so forth, right? So all of those activities which are done on an automated processing basis, individuals have the right to object to those things, and they have the right to ask for a human intervention instead of just asking for an automated processing to be happening, right? So these are the rights that have been granted under GDPR to individuals. Now let's talk about what are the lawful bases under which processing is generally allowed under GDPR. So the first and the foremost that we have is consent, right? So consent is where an individual is giving an informed, signal, or in a informed affirmative action to the, to the enterprise to be able to do certain processing activities for their data. Now talking about legal obligation. Now legal obligation is something like, when you need to, process the data for the purposes of complying with certain kind of regulations, let's just say employment laws, tax filing, or, any other, kind of regulatory reporting. So all of these, or let's say for defending yourself in the court of law, right? For all of these things, when the processing is required, it is called as legal obligation, which is the lawful basis for processing. Now, next you have is legitimate interest. Now, legitimate interest, what it means is that when an organization is processing the personal data to achieve their end goals, which are necessary for their business operations or their business functions. So let's just say, CCTV camera within the building, right, of fraud prevention, where they are checking your backgrounds, or they're doing a network security. All of these are important for the business to maintain its continuity, and they are going to be legitimate interests of the business while they're processing certain kinds of data, right? Now let's talk about contractual necessity. So contractual necessity, think of it, I'll give you an example of Amazon, right? So let's say you're ordering something from Amazon. So Amazon needs to know certain details about you in order to be able to provide you with certain services, right? So this is where contractual necessity comes. Contractual necessity is something like, that you have done your part of the bargain, and now to be able to provide you with certain services, they require certain kind of data from you to be able to do, or to partly perform their contractual obligation that is there. Now, right, now next we have is public interest. Now public interest is something which is, something which comes from an official authority or is a public mandate, right? Let's say, giving workforce data during a government audit that is happening, or let's say during Corona, during COVID, what happened was, a lot of health organizations, or a lot of health authorities were asking data from, different organizations. So that is for the public interest, right? And now vital interest is something when processing becomes utmost important for the purposes of protecting an individual's health or to ensure their safety. So let's just say that, if there is a workplace accident that has happened, right? So at that point, they will have to use the emergency contacts that have been given by you for the purposes of ensuring that you are safe and sound, right? So these are the lawful basis of processing under GDPR. Now, let's talk about consent as one of the most important things, right? So Article 6(1)(a) of GDPR talks about how consent needs to be taken from an individual. So there are six out of all the six lawful bases, consent is considered as one of the most important lawful bases. Now, how does a consent need to be taken? When a consent is to be given by an individual, it needs to be freely given, it needs to be specific, it needs to be informed, and it needs to be unambiguous. Now, what it means is that you cannot ask the individual, or you cannot force the individual to make a selection to be able to, let's say, browse certain things. Um, on a website, right? When you go on the website, I'll give you an example via a website. What does consent model under GDPR means is, there are no there when you land on the website and there is a a cookie banner that you see, right? So there are not supposed to be pre-ticked boxes, right? If you allow only necessary cookies, your experience of browsing through the website should not be hampered, right? And an individual needs to give a specific consent for any kind of activity to happen. And there is another concept called as bundled consent. What bundled consent means is that you are taking, in the garb of taking consent for, let's say, newsletters, you are taking consents for sending me not just newsletters but also sharing my data with some other entity. You're also taking my consent for the purposes of giving me different promotional calls, so on and so forth. So this is what bundled consent means, right? GDPR specifically allows for the fact that organizations cannot take bundled consent, right? And there has to be a privacy notice which clearly lays out how data is going to be used, who is going to use that data, how that data is going to be shared, transferred, how is it going to be consumed, for how long it is going to be stored, and so on and so forth, right? Now, let's talk about two of the important, personas, or two of the most important, people who are involved in the processing journey of, your personal data. So one is the controller. Now, think of the controller as the entity who's going to collect the data and is going to decide what is going to happen on your data, right? And then is the processor who is going to perform these activities on behalf of the on the behalf of the controller for that limited let's say limited scope that was decided amongst them, right? Now, what are the obligations that are there on the controllers and the processors under GDPR, right? So the first obligation that we have on the controller is that lawful basis needs to be ensured for each processing activity, and it has to be transparently communicated, right? They also need to ensure that purpose limitation is met and data minimization is followed at all points in time. Next is that data is at all points accurate, and only necessary amount of data is stored within the ecosystem of the enterprise. Essentially, they also need to ensure that the security, integrity, and the confidentiality of data is maintained at the highest level. And there is a fair amount of accountability, and the records are maintained to show the accountability of that organization to the regulator and also to the individuals, right? And also there is a special requirement around how the transfers are supposed to be done and what conditions are there under which the transfers will be allowed from EU to any other third world country that is there. Now, for a processor, the processor needs to ensure that they are processing all the data on the documented instructions of the controller, and they are not doing anything else with the data. The second thing they need to ensure is, if they are also going to sub-delegate the task, they need to ensure that they are taking proper care of that data. They're also informing their controllers. They're also ensuring that everything that is happening on the data set is within the purview of what their original contract with the controller was for. Now, it is also to assist the controller in fulfilling all the DSARs that are going to come to them, also ensuring that they are also adhering to the best privacy standards that are there, to ensure that the confidentiality and the security of data is maintained at all points in time. to also ensure in case if a data breach happens from their end, they're promptly notifying the controller so that the controller can notify all the data subjects that are involved in that breach, and to ensure that they're also informing the regulatory authority, right? And to also always be ready for audits and accountability and have records to show their compliance with GDPR. Now, let's talk about, there are certain technical and organizational measures that have been prescribed under Article 32 of GDPR, which talk about what are the things that an organization need to do in order to ensure that they are maintaining privacy within their enterprise. So one is access control. Now, access control, what it simply means is that, only those people who have authorization or authentication within the enterprise to be able to use certain data are the only ones that are using data, and we are not proliferating data. So what I mean by proliferation of data, it means is that the data should not be visible in such a manner that anybody within the enterprise without proper clearance and authority gets visibility over personal data of the individuals or the data subjects, right? Now, talking about privacy enhancing technologies. So things like, anonymization, pseudonymization, encryption, federated learning, and, cryptographic encryption, all of these are privacy enhancing technologies that an organization needs to follow in order to ensure that there is that the personal data is protected, and even if the data is lost, the individual cannot be exposed, right? Now, about integrity and confidentiality, I think we've spoken a lot about it. Data retention and deletion. So data retention is all about, ensuring that the data is retained only till the point it is necessary, and after that it is either going to be deleted or it is going to be anonymized, right? Now, regular testing and evaluation, what it means is that organizations need to ensure that they're assessing, evaluating, and testing their security controls to ensure that they are maintaining the highest level of integrity and confidentiality of data, right? There is also
Sorry to just quickly interrupt. I'm just very gently reminding you there's 10 minutes left. Very gently reminding. Thank you so much.
Sure. Sure. All right. So, so coming to training and awareness, it's more around, how data needs to be, how the staff needs to be, trained around what are the, privacy policies that we are following, what are the secure handling practices, and a DPO is the head of the vertical within an enterprise who manages the privacy for the enterprise, right? Now, talking about data breach management, GDPR talks about 72 hours of window where the organization needs to, inform the supervisory authority if there has been a breach, which can potentially cause, let's say, any, hampering or any delay or any risk to the rights and the freedoms of the data subject, right? Talking about the penalties, now there are two kinds of brackets of penalties under GDPR, which talk, one is 10 million euros or 2% of the global annual turnover, whichever is going to be higher is one of the penalty, and the other penalty that we have is 20 million euros or 4% of the total worldwide annual turnover. So whichever is going to be higher is going to be the penalty, which is going to be levied by the supervisory authority, right? I think I'm going to just skip this. In the interest of time, I think we've already surpassed, our allocated time, right, Alexander? If I understand correct.
No. There is still around 7 minutes left. So but we can also go to the Q&A. It is whatever you feel is. I see that there are a lot of questions.
Enough questions, yeah.
Yeah.
I think I'll be happy to do the Q&A because we could only cover GDPR in the stipulated time. I mean, I'll be happy to come back again and talk about DPDP again if there is a need. I think we can go for the Q&A then, Alexander.
Amazing. No worries. Well, I see that there's a Teams has given me list. So I was thinking maybe we just go through them.
Sure.
What I would definitely ask, thank you to begin with so much for an amazing lecture. It was really, really interesting. I really especially liked about the bit about the informed consent. That was, for me, really, really fascinating about all of the different parts of it. It was really great to hear about. So thank you to begin with very much. Now, for the Q&A, what I would just ask to all of the students, I know you've probably got lots of questions and are really eager to ask them, but please keep your questions quite short. We do not have loads of time, and the shorter that your questions are, the more time that we have for the answers. So with that being said, Chandra Shekhar, I will allow you to turn on your mic and your camera, and you can give your first question. So I hope that Chandra Shekhar, you should now be able to ask your question. But if not, then I guess maybe they cannot do it, or maybe are they having some tech issues? In which case, we can move to the next one, which is Taniru Vasu. So I will let you. I will also have you ask your question if you are able to. There is also just, you will see at the top of your screens, there is a Q&A box where if it is easier to type, you can also type in your question, if that is easier. I know sometimes with Teams, there's always the tech issues that we inevitably face.
Technology and its challenges, right? I think I think there are some glitches that are there. So why don't we have people post their questions, and then I can pick up, like, 2-3
Yes.
questions to answer if
That
and
sounds like a
more
good
if
idea.
time permits, right?
Absolutely, absolutely. So yeah, so it's on the top of your screens. You'll see a little bar, everyone, the Q&A, and it will ask you to start a discussion. And so you can ask your question there. We'll give people a bit of time to type, and then hopefully we will have some interesting. While we wait, I actually have a question. What I've kind of wondered, and I was wondering it actually before and definitely during, do you feel that with GDPR and data privacy in general, is there like any developments in terms of, now with AI and, you kind of see a lot of, deep fakes and these types of things where we can impersonate. How does that kind of negate, like the role of, LLMs? How does this affect data privacy? And is it making it more difficult to keep data, or?
I think what it has done is, and you made a very fair point, right, Alexander, which is around because we have so much of data, right? We've amassed so much of data that it is, practically very easy for LLMs to have deep fakes, and you can, just have a new identity created out of nowhere, right? Because there's just so much of data that is residing. I think what it does is it actually reiterates the faith within the organization to ensure that they're having the best data privacy practices, so that, just in case if that data is lost, and, tomorrow there are Frankenstein IDs being created out of them, and there are all sort of, frauds that are being done out of them, right? So I think data privacy within this, AI driven world becomes of paramount importance. And it also sensitizes organization to take a closer look at what kind of data sets they're collecting and storing. So,
Okay, interesting. And do you see governments, and like especially in the EU with GDPR, do you see them using this kind of like, or like kind of being able to, yeah, is there any way to keep up with it? I guess is the way. I'm not an expert in this at all, so excuse my my
No,
very basic language.
no, that's all right. I think, like I mentioned, right, and like I highlighted, there is if organizations who have been following data minimization and purpose limitation very religiously, they do not have so many issues because the data set that's residing with them is very limited. And there is also this perspective, see, from an enterprise landscape, just think of some 15 petabytes or 15 terabytes of data residing within their data lake. That's also a cost, and they're not going to gain anything out of it because data becomes outdated after a year, right? So what is it that you're going to do after a year with that data? If you've served the purpose of that, I think it is best to be deleting that sort of data, and you can keep the logs for the purposes of your reporting or your compliance journey and so on and so forth, right? So yeah.
I see we have a question from Dr. Shriram. So I will just allow the mic and the camera from him. Dr. Shriram is actually one of our partners, so he has been also very involved in the organization of the cyber school. So I hope, Dr. Shriram, are you able now to turn on your camera and your mic? I hope.
Yes, I hope you can hear me.
Yes.
Hello.
Yes, we can hear.
Hi, Mahi. Yes, I know Mahi from before, many times we've met. Great presentation, really, Mahi. So the question I had was quite simple and contemporary, that with AI, people can, with vast amounts of data, you can correlate and quickly pinpoint, right? For example, individual pieces of data you may not. Let's say, take an example, if you go on having data like saying you masked out the name, but there's a building in which you say that, yes, people above 85 years of age, people who have this kind of problem, something else, something, which is individual pieces do not constitute private information, but when correlated off, it can exactly pinpoint the people or the things that you are doing with correlated, especially with multiple devices, maybe IoT, maybe something else, saying that a person who tracks goes on this route and all that, though you have masked out those things, this is what is going to be a risk going ahead. So you can have saying that, yeah, you have this database, but then you run one AI algorithm which can crunch and create a lot of havoc for from the personal privacy point of view. Yeah. Thank you.
So I think,
yeah,
Dr. Sriram, what you said is, it's actually true, right? And this is what is happening. So all these deep fakes, like me and Alexander was asking before, all of these deep fakes, this is one of the reasons, right, why all of these things are coming. And this is going to be a potential risk, in the near future with AI and all of, privacy concerns coming up, and, with IoT of things and so many things coming up and so many new technologies coming up.
GPS, right? And so much data
lying around. Right. Yeah. I think what is important is a little cognizance, both from the individual's perspective and also from the organization's perspective. From an organization standpoint, I think it is most important for them to ensure that they're not having data sets just lying around, within their databases, which is, let's say, not properly encrypted, or it is not properly, anonymized or not pseudonymized. It's not stripped off its identity, so that even when the LLM is using that information, it is not going to make so much sense out of it, right? That is what we require. We do not require you giving them, unfiltered amount of data sets and then asking them. Of course, it is more intelligent. It knows what to do with that data set, right? So the idea is to ensure that the integrity and the confidentiality, of course, privacy enhancing technologies, you can have, noise being added to the data set so that a lot of things are not made sense out of the data set that you're sharing with the LLM models that are there, right? So I think this is what is of most importance from an organization standpoint.
Certainly, because it mentioned some data that never gets outdated. For example, I mean, every year, don't like your date of birth or biometric data or something that is your privacy data, which is your identity, and that remains. So regardless of whether other data is getting deleted, these must be safeguarded really well. Okay, thank you.
So just to give you an example, Aadhaar lying around here and there, or somebody's passport number for that matter, lying around here and there, of course is going to have catastrophic effects on an individual. Just by the virtue of knowing somebody's Aadhaar or their passport number, you can practically know a lot of things about that individual, enough to harm them. So,
yes. Thank you.
All right. Okay. Any other questions?
So don't forget to write them into the chat. I see we have a couple more questions. So we have one question about the critical differences between GDPR and DPD, the DPD Act. So I'm guessing you can probably give a whole lecture on this, I'm sure. But maybe I don't know if there's like top three maybe, or like the biggest critical difference.
So top critical differences that I can think, on the top of my head, and what you said is, Alexander, correct. I can give an hour's lecture just on the differences. But critical differences, okay. So GDPR has a segregation of, personal data and sensitive personal data, whereas DPDP Act has only personal data as the category. There is no segregation of, personally identifiable information and sensitive personal data. The second is the scope of DPDP Act is limited to digitalized personal data, whereas GDPR is more encompassing. It has got a wider approach, and also in terms of the rights that have been granted to the individual. So the rights that are there under GDPR are more broader in its approach, and under GDPR, that under DPDP there are some specific, very I would say India specific rights that have been given. So to give you an example, the right to nominate or the right to grievance redressal, these are rights which have been introduced under the DPDP Act. And also really talking about, I'll give you two more. So GDPR emphasizes on the importance of having a records of processing activity, whereas such importance has not been given under DPDP Act. Apart from that, GDPR talks about DPIA in all new high-risk processing activities. DPDP talks about only significant data fiduciaries to be doing the DPIAs. So yeah, it's a couple of differences that I could think of at the top of my head. Alexander, I can't hear you. Sorry.
Sorry, that was my fault. My mic was off. Thank you so much for that. That was really interesting. And I think it's time probably for one last question. I always like to squeeze one in, and so it's a bit of a quick answer, quick question. So with the right to be forgotten principle in laws like in GDPR, what are the practical and technical challenges for organizations to completely erase the person's data, considering backups, archived information, these types of things?
So I think you said it within your question, right? So one of the most prominent technical challenge that is there is that while you can remove it from, let's say, your active systems, removing it completely from your backups or your archivals is not possible, and it is also not recommended. Why? Is because you would require these, let's say, archival data or this, backup data for the purposes of meeting certain legal obligations in the near future. Let's say that, there's a customer who has asked for the right to erasure. The practical thing to do is to remove that person's data from the active repository that you have, from the active system, so that that person is not receiving any emailers, newsletters, so on and so forth, right? but not to remove it from the backup, because you might require it for the purposes of some regulatory reporting, or let's say an individual today, your customer wants you to erase the data, and you have erased that data, right? And tomorrow, a year later, that person only comes to you and says that, I am suing you for certain XYZ things. Now you need to defend yourself. How are you going to defend it if you erase their data from all the systems, right? So this is where the practical challenge comes. So I think what organizations generally do is they remove it from that active system, and they will respect the individual's right of asking for a erasure from that particular, let's say, vertical or that particular active system. So yeah.
Amazing. Thank you so much. These were some really great, like really detailed answers, and like I think we've all learned so much. So with that brings us to 5 p.m. here in the Netherlands. 8:30, I think, in Indian time. So a bit
8:30 in
later.
Indian time.
8:30. There we go. There we go. So thank you so much, Mahi Gupta, for the first lecture of the 2025 Indo-Dutch Cybersecurity School. We've got many more lectures coming up. For the students who are in the call, I would ask you don't go away quite yet, because we actually still have a little quiz that we do at the end. Mahi, you are more than welcome to stay for this quiz. It's just a bit of fun. But of course, if you need to go away, have dinner, whatever it is, you are more than welcome either way. So what I will do, I will just quickly share my screen. We do this via Mentimeter. Some of you might have seen it before. And it's just a bit of fun, 10 questions all about data privacy. Yeah, to kind of test your knowledge. We'll see how it goes. So hopefully you can see my screen now. And what you need to do, you need to go to menti.com. There we go. Menti.com, and then you see this code at the top. So you just need to fill this in, and you can do this on your laptop, on your phone, whatever device you have. We'll just give everyone a minute or two to do this.
Hey, Alexander, I'm going to
Hi
drop.
there.
It was really lovely to be here, and thank you for having me.
Thank you
Bye.
so much. Thank you very much, and have a great rest of your evening. Thank you.
Have a great day. Thank you. Bye.
Bye-bye. Amazing. So there's some participants already joining. I see we've got 16 people. Wait a minute or so longer. And so just go to menti.com and then this code at the top. So just to reiterate, this is not required for any of the certificates. It's just a bit of fun just to test yourself. Were you paying attention? Or yeah. Wait a little bit longer. And we do these quizzes at the end of every lecture. So it's just a fun way, to test yourself. And it's not a competition. It can be if you want. No, I'm joking. Okay, let's go to the first question. There's 10 questions in total, and they are multiple choice. So, what is the primary goal of data privacy? So we have most people going, everyone is going for one answer so far. Very confident, I think, everyone is. We have one person voting for to improve internet speed. Give you 10 more seconds for the last couple of people. And I can reveal that the answer was, yeah, indeed, most people got it correct. To protect personal and sensitive data from unauthorized access. Very good. Okay, on to the next question. Which of the following is a key principle of data privacy? Again, some people are very confident with their answers. I think there's pretty much unanimity in people's opinions here. A couple of people choosing something else, but I think we'll give people 10 more seconds to choose. A couple more people joining as well, so that's always fun. And I can reveal that. Oh, yeah, there we go. Most people got it really good. You guys are acing this. Organizations should collect the minimum amount of data necessary. Really good. On to the next one. Why is data encryption important for protecting privacy? So again, most people, but we have a couple people guessing something else. A bit more disagreement in this one, but still most people going for the second answer. Let's give everyone 5 more seconds. 5, 4. And there we go again. Majority, it ensures that only authorized parties can read the data. Really well done, really good. Which law governs data privacy in the European Union? So I think this is a pretty easy one compared to the others. Yeah, I think everyone's got this one. Very nice. Amazing. Give people 5 more seconds. Is it SOX? Is it GDPR? Is it something else? 5 more seconds. Yeah. And yeah, absolutely unanimity. GDPR, exactly. It's exactly what Mahi Gupta was talking about. So very good. Short question. What is a data breach? A lot of unanimity again. I think all of you are acing this. You are all A-star students. 5 more seconds. And there we go, exactly. The unauthorized access and exposure of private data. I mean, so far, all have been correct so far, so this is really, really good. How can individuals protect their personal data online? A couple of different options here. Is it going to be full unanimity again this time? So far? Five more seconds. There we go. 71 people answered this one. 71 people got it correct. Really well done. Really, really well done. And well, we just had a question about this actually. Were you listening to the answer by Mahi? What is right to be forgotten under GDPR? Amazing. Couple more seconds. And there we go. Majority got it correct again. Really, really well done. The right to erase personal data held by organizations. Really, really good. Okay, which of the following is a risk of poor data privacy practices? Here, are we going for unanimity again? So far, so far. 5 more seconds. And it is, there we go. Yeah, exactly. Exposure of sensitive personal information to unauthorized individuals. Well done. Why is data minimization important for data privacy? So far, so good. 5 seconds left. And well done. There we go. Exactly. It reduces the amount of sensitive data collected, lowering the risk of exposure. Really good. And I think this is the last question. Okay, so last question. Can we go 10 for 10? What is one way organizations can ensure compliance with data privacy regulations? I'll give you a couple more seconds. Which one is it? Which one is it? There we go. Amazing. You guys have done such a great job by implementing robust data protection measures and policies. So, well done, everyone. That was just a quick quiz, just to make sure you paid attention. Thank you all so much for coming. This was the very first lecture of the Indo-Dutch Cybersecurity School 2025. Tomorrow we have 2 lectures, I believe. You can see on your study guide what they will be about. Some interesting topics. I'm really looking forward to it, and I really hope you are too. I wish you a great evening, and we will see you all tomorrow. Bye-bye.